they would still, Senator, have to apply with what the federal Constitution
No,
said
they wouldn't.
under the Supremacy
Do
Clause.
you know what adequate and independent state grounds means?
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can.
Didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
but you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it.
Okay. Do you know what the privileges or immunities clause is?
With respect to my answer would be the same on that.
You don't know it either.
Hey folks, welcome back to the channel. It's Freedom Forge here. If you love the Constitution, believe in American values, and want to keep this country free, you're in the right place. Go ahead and hit that subscribe button right now. Today we got to talk about one of the most jaw-dropping, frustrating, and frankly embarrassing moments I've seen out of the Senate confirmation hearing in a long time. Senator John Kennedy, God bless him, sat down with a group of judicial nominees, and folks, what I saw should terrify every freedom-loving American. Let's break down what happened, why it matters, and what it says about the future of our country if we keep putting people like this on the federal bench.
Madam Chair, Judge Dudick, did I say that name right?
That's correct, Senator.
All right. What's the warrant requirement?
Well, before the court would issue a warrant, you have to assess to make sure that there's probable cause to either search the place.
When's a warrant required?
Excuse me?
When is a warrant required?
The general rule is a warrant is required any time that the government wants to search a person, place, or thing.
Could you speak into the mic?
Oh, I'm sorry, Senator. Yeah, I said the backdrop rule is that a warrant is required any time the government wants to search a person, place, or a thing.
And to arrest you, right?
There are some exceptions to that, but generally, yes.
Okay. And there are exceptions to the warrant requirement for searching and arresting people, are they not? Are there not?
Yes, Senator, there are.
Okay. Suppose the Florida Supreme Court ruled that here in Florida, we're not going to recognize any exceptions to the warrant requirement. You have to have a warrant to search someone, and you have to have a warrant to arrest someone. Mm-hmm. No exceptions. Can the Florida Supreme Court do that?
Well, Senator, under the Supremacy Clause, they'd be bound by what the Fourth Amendment dictates. Of course, they're free to make their own requirements as it.
What if the Florida Supreme Court did it under the Florida Constitution and not the federal Constitution?
Well, they would still, Senator, have to apply with what the federal Constitution said.
No, they wouldn't.
Under the Supremacy Clause.
Do you know what adequate and independent state grounds means?
Sure. Of course, I would understand that they could have independent and adequate state grounds for state law, but they.
No, they don't. As long as you don't take away rights, but add to them, a state can do whatever it wants to under its state constitution, can it?
Yes, sir. Yes,
But
Senator.
that's not what you just said. You think the Supremacy Clause applies? The Supremacy Clause applies.
Well,
You want to change your answer?
Senator, I would like to change my answer to the extent that I agree with you that the Florida legislature or Florida could do exactly what you said. I meant in my statement is that.
Trust me, it can. Judge Pruitt, I'm sorry, I can't see that far.
It's Judge Pratt, Senator. Yes.
Judge Pratt, I apologize. I can't see that far. Can a state legislature pass a law that discriminates against a group of people over another group of people for inferior treatment?
Well, Senator, the federal Constitution and the state Constitution both contain protections against various forms of discrimination.
But can a state legislature say we're going to treat this group of people differently than another group of people?
So I think, Senator, an example where a
But
legislature
tell
could
me first if a state can do that.
Yes, a state can, for example, require a driving age, which discriminates on the basis of age, to say, for example,
When can a state legislature not do that?
when it's seeking to do so under a basis that is protected under the state or federal
Okay,
constitution.
good. Judge, tell me about the privileges and immunities clause.
The Privileges and Immunities Clause, there's a privileges and immunities and a privileges or immunities
Right.
clause. There's one of each. One of them relates.
Privileges and is what I'm asking you about.
I believe you're referring to what came through in one of the Reconstruction amendments and discussing the fact that that the privileges and immunities of citizenship would be extended
Well,
under those.
first, what article is it in?
I believe it's in the 13th Amendment.
No, fourth. Article 4. What does it do?
Senator, you have pinpointed a question that in my 9 years as a judge, in my decade of private practice before this, my 2 years as a law clerk, my 2 years on law review in law school, including a year as editor-in-chief, didn't ever come up.
You tell me you don't know?
So it's an interesting question.
Yes,
and
ma'am. I know it's interesting. That's why I asked it.
Yes,
But you don't know the answer. Just tell me. I got a lot of ground to cover here.
I would be very happy to research it
Okay. Do you know what the privileges or immunities clause is?
with respect to my answer would be the same on that.
You don't know it either.
Well, with respect to the privileges and immunities of citizenship, my recollection is that,
Privileges are immunities.
yes, my recollection is that was discussed in one of the Reconstruction amendments.
Which one do you know?
I believe it was the 13th or the 14th.
Okay. All right, Judge. What's Title VI of the Civil Rights Act of '64 do? Ma'am?
Which judge?
This judge down here on the far end.
Artau?
I can't see that
Okay.
far.
Just making sure, because there's 4 judges there. Judge Artau, I'm going to let you answer that briefly.
Hey, I want to reclaim my time, Mr. Chairman.
You can
Madam
answer that
Chairman.
briefly.
Judge, what's Title VI of the Civil Rights Act do?
I believe that ensures that people are treated equally in any places that they would be, that they would not be discriminated against.
In all cases?
Refresh my recollection as to what you were referring to,
I'm
Senator.
referring to Title VI of the Civil Rights Act of 1964, which you're going to see every other Thursday as a federal judge.
So I believe that's under the Commerce Clause. They wanted to make sure that there was not any discrimination going on with regard to race, and that was addressing it.
It prohibits discriminating on the basis of race or color or national origin under what circumstance? Do you know the answer?
Under any circumstances where you're providing services to people.
No, it's only if you're getting federal money. You need to brush up on that one. I'm way over my time. Thank you, Madam Chair.
So here's how it started. Senator Kennedy simply asked one of these nominees, Judge Judic, about the most basic Fourth Amendment stuff. When is a warrant required? You'd think, if you're about to be a federal judge, you'd have a rock-solid answer. This isn't obscure legal trivia. This is intro to law school material. And she fumbles it. She can't clearly say when a warrant is needed to search or arrest someone. She stumbles through exceptions, gets tripped up on the difference between state and federal constitutional rights, and, get this, misunderstands the Supremacy Clause. Senator Kennedy even has to remind her about the concept of adequate and independent state grounds. If you're going to sit on a federal bench, you should be able to recite the basics of the Bill of Rights in your sleep. The founders put those protections in place for a reason, so government can't trample on our liberties. If a judge doesn't even understand when the government needs a warrant to search your house, what's to stop them from rubber-stamping government overreach? Next, Kennedy asks another judge, Judge Pratt, about whether a state can pass a law that discriminates against a group of people. Pratt gives an answer about driving ages and other neutral examples. Eventually, she gets to the right constitutional principle. You can't discriminate based on protected classes like race, religion, or sex. But here's the thing. Why does it take so much prodding to get an answer? Why can't they just say, no, Senator, the Constitution is clear. You can't pass laws that treat people differently based on race, sex, or religion? Why so much dancing around? Are they afraid to commit to the plain meaning of the law? Are they so worried about offending the woke mob or upsetting the Biden administration that they can't just say what the Constitution says? It's this kind of wishy-washy, activist judgmentality that's corroding our legal system. The law should mean what it says, not whatever a judge feels it should mean on a given day. And then, folks, it gets even worse. Kennedy asks about the Privileges and Immunities Clause from Article 4, one of the oldest, most fundamental parts of our Constitution. Not a single judge can explain it. He asks about the Privileges or Immunities Clause from the Reconstruction Amendments. Again, blank stares. One judge even says it's in the 13th Amendment, which it's not. It's in the 14th. How can you be a federal judge and not know what's in the Constitution? These are the very provisions that protect our rights as Americans. Freedom of movement, equal treatment across states, and civil rights protections born out of the Civil War. If these judges don't know the text, how can we trust them to defend our rights? If you or I had to take a citizenship test, we'd have to know this stuff. Shouldn't a federal judge have a higher standard? And finally, Kennedy asks about Title VI of the Civil Rights Act of 1964. The judge gives a vague, wandering answer about treating people equally and not discriminating. Kennedy has to remind her, Title VI only applies to organizations that get federal money. If you're going to be a federal judge, you should know what laws you're supposed to enforce. This is the problem, folks. The left has prioritized ideology over competence. They want judges who will rule based on their personal politics, not judges who know the law and will apply it fairly. We're seeing the result. A federal bench filled with people who can't answer the most basic questions about the Constitution and civil rights. Now, you might say, so what? They fumbled a few questions. But here's why it matters. These judges are the last line of defense between you and government overreach. They decide if your rights are protected. If they don't know the text of the Constitution, how can they protect you? If they don't understand the limitations on government power, how can they stop tyranny? We need judges who will defend the Constitution as written, not rewrite it to fit some radical agenda. So what can we do? First, keep shining a light on these hearings. Share this video. Send it to your friends. Let people know what's happening. Second, call your senators and tell them to oppose any nominee who can't pass Constitutional Law 101. Third, get involved. Vote in every election. Support candidates who respect the Constitution and will fight to keep America free. Because if we don't stand up now, we may lose the freedoms that make this country great. All right, patriots, that's it for today. If you love freedom, if you love the Constitution, and if you want judges who actually know the law, join this channel and stay in the fight. It's up to us to keep the flame of liberty burning. God bless you. God bless Senator Kennedy, and God bless the United States of America. Don't forget to like, subscribe, and leave your thoughts in the comments. What do you think about these judicial nominees? Am I overreacting, or does this scare you too? See you next time.